All right. Hi, everybody. Thank you for having me today. I'm Holly Beck. I am a divisional supervising attorney in the housing unit at Community Legal Services. I'm putting my contact information in the chat. I apologize for any background noise. I'm not in my office, so there you may hear ambient noise or voices. But I'll try to minimize that. And I'm excited to be with you here today to talk about eviction records and some things that the city of Philadelphia has been doing to try to minimize the impact of eviction records on people seeking housing, as well as how much there is still to do and a role for anyone who cares about the issue and the folks impacted by it to play a part. So I am going to share my screen. Okay, can you all see the slideshow? Okay, great. So just for a little bit of background, and folks may know some of this, but I think it's an important context. Eviction records impact 1 in 14 renters in Philadelphia. Before the COVID pandemic hit us all in 2020, landlords in Philadelphia filed just about 20,000 eviction cases every single year. And so each of those records is still visible on the internet as there is no mechanism for sealing those records. And that's true even when a tenant won their case in court. I was in court last week and saw a landlord and tenant work out a case, and the tenant hugged the landlord at the end of the case. I mean, that's granted, that's an extreme example, but just to illustrate the point, that tenant still has an eviction record because private tenant screening companies scrape court records in Pennsylvania and everywhere, and then sell that information to landlords when a tenant applies for a rental property. And there are hundreds of tenant screening companies across the country, and they are able to access any case that's been filed, no matter what's happened in the case. And often all that's reported to the landlord is that an eviction case existed. The outcome isn't necessarily reported or reported correctly. So that is the kind of dismal backdrop for everything we're talking about today. Prior to the pandemic, which are the last years we have data for, a quarter of all eviction filings didn't result in a judgment, meaning either the tenant won in a trial or the landlord dropped the case before it ever saw a judge. And yet all those folks still have eviction records for the purpose of their housing applications. The same goes for judgments by agreement, which are the chief form that settlements take in Philadelphia municipal court in eviction cases. So they're agreements, but they're still judgments. So often, even if the agreement is for a tenant to stay in their home, follow a payment plan, and they go ahead and do exactly that, and they're never evicted, that still shows up on their record as an eviction. And as folks on this call probably know very well, it's been a real struggle to increase the percentage of tenants in eviction cases that have access to legal counsel. And so the vast majority of landlords are represented, while the 10% of tenants has gone up a little in recent years as the city starts phasing in right to counsel in the zip codes that it started, but still the vast majority of tenants are unrepresented. How big a problem is this? It's a very big problem because the vast majority of landlords do rely on a tenant screening company. The application fee that tenants pay when they apply for housing usually goes towards one of several hundred private tenant screening companies. And the problem is that a tenant is never really able to know ahead of time what screening company the landlord is going to contact for a report. And so they can't access the report ahead of time to look at it, to see what it's going to say. Because unlike a credit report, we're all encouraged to go online every year and check our credit report for errors and things like that. But these tenant screening reports don't exist until a landlord requests them from one of several hundred tenant screening companies. So that's where we are. And against this backdrop, this Philadelphia City Council enacted the Renters Access Act, which went into effect in October of 2021. What the Renters Access Act does is two important things. First, it requires landlords to give all applicants written screening criteria that is uniform across all applicants. That is, landlords aren't allowed to use one set of screening criteria for one family who's applying for housing, maybe depending on how they look to the landlord, or their language that they speak, or the fact that they have children, any number of categories that have been used in the past and today to discriminate in housing. The point of the uniform screening criteria requirement is that each applicant, or every applicant, gets the same set of criteria so that they know they're being treated fairly in the application process. The law also says that that uniform screening criteria cannot include a broad prohibition on any eviction record at all, and it cannot include a sole reliance on credit score. In other words, landlords are not allowed to say any eviction, no luck, and they're not allowed to say that they have a minimum credit score that a tenant needs to have. The second part of the law has to do with the process available to tenants when they're applying for housing in their individual situations. So if I'm applying for housing and the landlord denies me for any reason, the landlord has to give me the reason in writing. So that can be email or text is also in writing, depending on how big the landlord's business is. But they have to say why in writing. And if they rely on any third-party documentation, such as a tenant screening report, they have to give me a copy of whatever they relied on. And I'm going to pause here, and this is really important because historically, tenants have had such a hard time accessing tenant screening reports. As I said a moment ago, it's very hard to know which company is generating the information that led to the denial unless I can see the report, which should have the name of the company involved on it. And it'll also say what they're reporting to the landlord so that I can then correct it if there's misinformation or inaccuracies on it. Maybe they have the wrong person. If I have a common name, this is especially problematic in communities of color. The Consumer Financial Protection Bureau put out a report last year, I believe, saying that that name commonality is more prevalent in communities of color, and therefore the risk of name-only verification is higher. That is a less reliable way of making sure that someone's record is actually their record. So if there are errors on the credit report, on the tenant screening report, getting a copy of it lets me know that. And then the Renters Access Act gives me the right as the tenant to seek reconsideration from the landlord. And that can look a couple different ways. Tenants only have a few days to seek reconsideration because the rental clock is so rapid. But if I go back to the landlord and say, hey, and it's always best to do this in writing, either there's an error on my tenant screening report, here's actually what happened, case was withdrawn, we reached an agreement, this was more than 4 years ago, all of those categories are protected under the Renters Access Act. Or I was evicted at some point, I fell on hard times, it was a difficult period, but I'm back on my feet. I have a job that I can provide documentation of. I can provide a letter of reference from an employer, a neighbor, support, a school, or I have a family member who's going to live with me and help pay the rent. So this additional evidence, it can look like anything that the tenant's able to show the landlord to support their rental application. And the landlord needs to review that information. And if they rent more than, I don't want to give the wrong, I think it's 5 units. If they rent more than 5 units in the city of Philadelphia, they need to offer the tenant the next available unit if the same unit still isn't available. And the reconsideration resulted in an approval of the tenant. I said that in kind of a convoluted way. If the tenant succeeds in persuading the landlord to approve their application, the landlord has more than 5 units, they need to offer the unit. Sorry about that. They need to offer the tenant the next available unit if the same unit isn't still available. And these are the categories that landlords are prohibited from denying applications based on. If the case didn't result in a judgment at all, if the judgment has been satisfied or vacated. So a lot of tenants don't realize that they have an open judgment from years ago that maybe they haven't paid off yet. And we can sort of advise them about the benefit of trying to pay it off, because then you can get it marked satisfied or vacated, and then tenants protected under the Renters Access Act. If the tenant's currently in a judgment by agreement or finished a judgment by agreement, or the eviction case or the judgment in the case is more than 4 years old, or if the case was filed during the COVID-19 emergency period, with a few limited exceptions there. We already went over this, and you don't have to memorize this. We have all this information online, and I'll put the link in the chat after this. So this is the timeline for reconsideration. As I said, it's really quick. 48 hours is what the tenant has to excuse me, request reconsideration after receiving written notice of the denial. And then they have 7 days to provide the additional documentation to the landlord. And this is just written down what the possible additional evidence could be. I just blazed through all these slides a few minutes ago. Okay, so I didn't get to this part yet. What happens if the landlord doesn't comply with any requirements of the Renters Access Act? If the landlord doesn't provide uniform screening criteria, or if the screening criteria they provide contains prohibited considerations, the Philadelphia Commission on Human Relations can investigate and sanction the landlord. So they are enforcing that part of the law. Everything else is, excuse me, everything else having to do with individual tenants' applications, the only way for folks to enforce that is by filing a small claim. And we have instructions on our website for how folks can do that. They don't need an attorney. We at CLS have some capacity, some limited capacity to help folks with that. The majority of our time is spent defending tenants in eviction proceedings. So that's why we're not able to do more. But we do advise folks. We'll write our clients letters after their court cases settle in anticipation that they're going to be looking for housing. And we'll say, this is how the case ended up under the Renters Access Act. This case cannot be a basis to deny the tenant housing. We have an email address where we are encouraging folks with stories of how they've been impacted by their eviction records to send us their stories. And they can send it directly to this email address or just to me, because I checked that email address. We are gearing up for a legislative campaign. I'm going to stop sharing my screen now. You may already have a sense about the limitations of the Renters Access Act. It's wonderful to have these protections, and yet they are hard to enforce, and they don't go all the way. And there will always be imperfect as long as we're relying on landlords to know their responsibilities and tenants to know their rights. So what we at CLS are hoping for is for Pennsylvania to do what it did in the context of criminal records in 2018 with Clean Slate, and work to seal eviction records, which would take the responsibility out of the hands of landlords, because they just wouldn't see the eviction records anymore. And tenants wouldn't have to know their rights because the sealing would happen automatically at the level of the courts. So I would encourage anyone on this call who feels inspired about the issue or enraged about the issue to email me, because in order to get a state law passed, we are going to need a coalition that includes as many people from as many professions and walks of life and backgrounds and skills as possible. And we have a Philadelphia record sealing coalition that meets every 2 months. Mara is a frequent participant. So that's one way to join. But even if you can't come to those bi-monthly meetings, there are other ways to plug in. And like I said, this is going to be a big effort of ours in 2023. So we welcome anyone and everyone who cares about equity, about people's ability to move forward with their lives and provide for their families after falling on hard times. Fairness in technology, fairness in consumer reporting, and access to safe and stable housing for all. So I will end there with the presentation, and I welcome any and all questions that folks have.